Good afternoon all. This is part one of the $170 speed camera ticket. Well, not even a speed camera ticket, this is just a speeding ticket. I received it on the 28th of April. That's when I got the thing in the post, and it alleges that it was on the 15th, according to this here. We'll just read it out. Officer DLAP 15 alleges exceeded the posted speed limit of $170. They're saying that it was more than 20 kilometres above the speed limit and therefore 35 demerit points. Sure, if they can prove it. And it says, let me just move this across a bit. Yep. And other than that, all the other information they seem to have pulled off of what's related to the registration plate number. Now, first off, this is the little bit of footage I have of on that same day. I'm actually coming the other direction, and you can see the cop is still sitting and hanging around the change of speed sign area. Okay, so as you saw in the footage, he's still sitting there, and I'm not going to say how long ago that was or whenever, but he's still sitting there. So my response to getting the ticket was pretty simple, and this is what I've seen through. It was dated on the 3rd of May, so literally less than a week, 5 days after receiving it. I sent it to the Police Infringement Bureau. They've got to give their postal address as well. By email at tickets at police, as you can see, and to whom it may concern. We refer to your, now, just before I start reading, we refer, now I'm speaking in a third person because they're talking about the legal person Mark Donald Eric Keane, which is a capacity I can represent myself through in commerce or in legal society or in various different capacities. So whenever I myself, Mark, are responding to these sorts of things, I will always do it in a third person thing. They do it to us. Alright? New Zealand Police will never say I. New Zealand Police is we. Alright? Because it's an organisation, it's a group, it's more than one person. Okay? It's a body corporate, unincorporated body or corporation soul. That's what a legal person is. So, yeah. So we refer to your correspondence in relation to an infringement notice PV 6212109 received via post on the 28th of April 2022. We believe New Zealand Police have made this allegation in error. Therefore, we wish to exercise our rights under New Zealand Bill of Rights Act 1990 Section 25A, which is the right to ask for an independent and impartial court to hear the matter. And elect for and give notice requesting under the Summary Proceedings Act 1957, Section 21.6. Summary Proceedings Act 1957, Section 21.6 means that if you're going to request a hearing, it must be in writing and it must be from the person who received the notice. So it's not a big issue, I'm just pointing out that I'm following their own fucking rules. Alright? So yeah, 21.6, a fair and public hearing by an independent and impartial court to discuss this matter. Whenever you go into court and you're standing in front of a judge, make sure that's your first question. Your Honour, am I to be heard by a fair, independent and impartial adjudicator? Because they can't exactly say no. But you make sure you get it on the record. And then when they start acting bias and everything else, then are going against what they told you in their own proceedings. Moving on. So yeah, public independent and derive any and all evidence and facts relied upon by New Zealand Police to support this allegation presumed against Mark Donald Eric Keane with the intent to gain resolution. I just want to go there and resolve the matter. Okay, so then I attach them, summary proceedings, section 21.6, which is exactly what I was talking to you about, and then carry on. Should New Zealand Police choose to withdraw this allegation against Mark Donald Eric Keane in relation to this matter without prejudice, no further action by New Zealand Police will be required. Mark Donald Eric Keane invokes and maintains the right, in accordance with New Zealand Bill of Rights Act section 25C, a presumption of innocence in relation to the minimum standards of any and all criminal allegations. 25C basically means that's the minimum standards of a person charged under criminal charge, and 25C is your right to shut the fuck up and be presumed innocent. In fact, shut the fuck up might be 25D. But anyway, moving on. Mark Donald Eric Keane maintains and invokes the right, in accordance with New Zealand Bill of Rights Act 1990 section 25D, to not be compelled to be a witness or confess guilt in relation to minimum standards of any and all allegations. So like I said, 25D, shut the fuck up. It's not for you to say, look, I wasn't driving that fast or I wasn't doing this. It's for them to establish that you were in fact the driver of the vehicle. Most speed camera tickets, most camera tickets don't actually show you a likeness of the driver, especially if it's taken from behind. So if they've got no evidence of that, it's kind of hard for them to prove the case, isn't it? Think about it. I mean, there's lots of other ways of doing things, and I'll show you a few of them as we go through the procedure with these guys. Now let's see, what else do I say here? And then I've attached New Zealand BORA 1990 section 25 in its entirety, so they can see that. I've attached New Zealand BORA 1990 section 24, rights of a person charged, so they can see all of that. 24A, shall be informed promptly and in detail of the nature and cause of the charge. Remember that, because I haven't been informed yet. Nothing in that speed camera ticket informs me of the cause and nature of a charge. It informs me of an alleged infringement notice. Alleged being the key word. Now, next page, as Mark Donald Eric Keane gives notice requesting under the Summary Proceedings Act 1957 section 21.6 a fair and public hearing by an independent and impartial court to discuss the matter, please supply under the Criminal Disclosure Act 2008 section 13.7b initial and full disclosure as specified within the Criminal Disclosure Act 2008 sections 12 and 13 in relation to this allegation. And then I attach them section 12, which is initial disclosure. That's everything you're entitled to have before giving a formal plea. Alright? You should be here. Most of the fucking cops, if you show up for a first call hearing where you've got to enter a formal plea with these guys, if you actually show up instead of sending an appearance in, a notice in, then the first thing they'll do is try and hand you all of the summary of facts and witness list and all of, well, sorry, not summary of facts, a copy of the charging document, the summary of facts, your previous criminal and traffic history. They'll try and hand you all of that on the day, and therefore you've been given initial disclosure. What they should be doing is giving it to you well before the date that you have to enter a formal plea. Otherwise, what are you supposed to read it all there and then, but when the judge walks in the room? No. Never accept anything on the day from these people. Ask for them to please send it via post or email it to you. That way you have a record of it being sent to you. Okay, they will say, well, if it's been sent in the post, it's been deemed, and if it's not registered in the post, tough shit. They've got lots of ways of getting around things. I like to do things via email because you can't exactly say I didn't send an email when I have records to say otherwise. So, yeah, anyway, that's section 12. I'll move on to the next page, and you'll see it carries on with section 12 a bit more, and then section 13. Now the point I'm bringing up to him here is in section 13, which is full disclosure. Now the reason I'm asking for full disclosure before a formal plea's been entered is that because you're requesting a hearing in writing, then that is deemed as not guilty. So if they're going to deem a not guilty plea has been entered, then, you know, before a formal plea's been entered, if they're going to deem it, and for the benefit of the doubt, call it not guilty, then they should damn well supply full disclosure. They won't, but that's what they should be doing. So, and here we go. So you've got the full disclosure, and this is where you get witness lists, any supporting briefs of evidence, interviews, videos, yada yada yada. It just goes on and on and on. But I've highlighted section 7 here to avoid doubt. A reference in subsection 1 to pleading not guilty includes B. Requesting a hearing in accordance with section 21(6) of the Summary Proceedings Act 1957, which, as you clearly saw, I included above. Unless the request is accompanied by an admission of liability or admission of guilt. Yeah, not going to happen. It's for you guys to prove guilt. It's for me to stay presumed innocence. I'm just keeping my role. Sorry. Now, right at the bottom here, I've said, notice all correspondence will be recorded and published on multiple platforms for maximum accountability and transparency in accordance with New Zealand Bill of Rights Act 1990, Section 14. And then on the next page, I'm just saying to them, notice failure to respond within 28 days shall constitute a tacit agreement. This is a way to make sure you get a response back. Considered a tacit agreement that New Zealand Police have failed to supply or provide for inspection the evidence and facts relied upon by New Zealand Police to support the above mentioned allegation. All in regard, signed by me, and as you can see, Mark Donald Eric. That's me, the man, given those names at birth. And then there's the corporation or body corporate unincorporated soul. We'll call it Mark Donald Eric Keane, all in full caps. If you want to know more about various capitalizations, look up capitis, dominutio, minima, or maxima, or media. Those are the 3 states of a signature. Alright, you can look up what those mean. They all represent different things, but that's kind of why you'll always see capitalization on your bank on your bank statements. But if you get your original birth printout, it's always capitis, dominutio, minima, which is just your initials only capitalized. Media is the full capitalization of your last name, and maxima is complete capitalization of everything. Okay, moving on. So that's what I sent them, and then of course I sent them an email saying please see the attached where are we here? Good afternoon, please refer to the attached PDF. All in regards me, you don't need to say anything more. You don't need to go into a big fucking emotional spiel. They don't give a fuck anyway. So don't waste your time. Just write something like I've done, and I will be making these. I will be making a template of this letter for anyone that wants to use it. And the links will be in the description to my Google Drive links, which will send you straight to the, we'll call it, response for a speeding ticket. Okay, so this is for a speeding ticket where the officer pulled you over. Okay, it's not a speed camera ticket. Okay, because there's various things you should ask for differently there, like a camera, or like a photo, should I say? Anyway, so yeah, do that. Then you've seen the PDF, NZPIB, that says there on the email. That's what I've just read out to you and showed you. And this is their response. It says, Tēnā koe, we acknowledge your request for a court hearing on this matter. And this was on May the 10th they responded, so it took them a full week to respond to an email. So be it. You may, we acknowledge your request for a court hearing on this matter. You may still receive a reminder notice. A reminder notice is a computer-generated notice that is posted after the first 28 days has passed, which will advise you to make a payment of the infringement notice. Do not make payment if you wish to proceed with the hearing request. You can no longer accept, or we can no longer accept payment for this matter as it has been set down for a court hearing. Well, no, it hasn't, because I haven't seen a notice of proceedings yet. I haven't seen a notice in respect to an infringement offence. I haven't seen anything like that come through the post. It's been a while. This was on the 10th of May they sent me this. It's now the 22nd of May. So it's taken them 12 days to stick something in the post? Or does it take them 12 days to fabricate shit first? Or is it because I'm asking for full, they need a brief of evidence from the officer and need to get all that sorted pretty quickly? Who knows? If you have made a payment in error, no, and would still like a court hearing, please respond to this email ASAP and request to have the payment refunded, that you would still like to proceed with the hearing request or not. Why would I request a hearing and then make payment? How ridiculous. An email will be sent to you once your court hearing request has been processed. Well, there you go. I haven't received an email yet, and it's been 12 days. Perhaps the courts are slipping up. Your defendant's disclosure will be posted to, and gives my postal address. If this address is incorrect, please reply with the correct address to this email within 5 days. Well, it's not incorrect, so we'll leave it be, because they're going to also post me the disclosure instead of emailing it to me. Ridiculous. And I might point out the notice of proceedings, or the charging document, is part of initial disclosure. So I would expect that to come with the defendant's disclosure postal address. But if they're going to let me know about the court hearing via email, they can as well. I would think, instead of using snail mail, that emailing would be better. But no. If you wish to send us the disclosure to an address that you do not reside at, you must request this in writing. If I wanted it, I would have put it in my request for a court hearing, wouldn't I? Let's see, moving on. If you no longer wish to proceed with your hearing request, please advise us ASAP. Yeah, because it costs them money to file the court hearing, doesn't it? Its court costs $30. Big bucks now, guys. Unable to cancel the proceedings, and you may be liable for the Ministry of Justice court costs on top of your infringement fee. No, I wouldn't be. No, I wouldn't be at all. If I request a hearing and then, according to this letter, tell them, no, actually I'll change it and pay for it, I'm not liable for anything, because liable means upon conviction. You guys would have to take me to court to prove that I'm liable for that, wouldn't you? Just saying. This is the bullshit they send you to scare you. Ngā mihi, Emily Silverstone, we thank you. Oh yeah, we thank you for your patience and consideration during this time. During what time? During what time? Is it supposed to be a spiel about COVID and resources being skimmed or something before that paragraph or that line? Gotta wonder. Emily Silkstone. So that would be emily.silkstone@police.govt.nz. And she's the Customer Supports Officer for Court Adjudication Section. So very handy, lovely. It's always good to know people that you can contact direct, isn't it? And it's always first name followed by last name at police.govt.nz. Or their QID number. Alright, so that's what I got from Emily. So that's where we're at the moment, guys. I am waiting for initial and full disclosure. Let's see if they adhere to the rules or if they start making procedural errors straight away. And we'll see if the judge or JP does. Now, I haven't gone through and contacted the registry or anything yet because I don't even have a CRN number. I may contact them, sending in an application to record, but why fucking bother? You know, I mean, why bother? They're going to treat me like I'm recording anyway, because that's what Waitakere Courthouse is like. Remember, this is where the yip Chihuahua fucking court security officer came out and tried having a go at me on the sidewalk for using a camera. That was before the law was changed, and they changed the meaning of the word court to include even the footpath directly adjacent to the courthouse. If you're across the road, you're fine. But the footpath is even considered part of the court now. They changed that, I believe it was in July 2018 or 2019 they changed that. There's the Court Matters Bill or the Court Security Act. I believe it's somewhere in there. But yeah, I don't want to quote myself because I'm not too sure where. Yeah, so that's where I stand, that's where we're at. If they want to say that I broke a law, as always, I'm going to maintain my presumption of innocence and stay innocent of anything until they prove it in a court of law, providing they follow their own rules and procedures and regulations, which they never do. So we'll see if it works any better this time around, guys. As we know, the previous 3 court matters I've been dealt with over since 2017 I won, 2018 I won, and Steve won in 2020. With that ticket, was dismissed as soon as he showed up. And in the 2021 was Steve's $120 speed camera ticket. That showed quite clearly that you can simply set in a memorandum or novation called a notice of appearance with your not guilty plea entered, and again requesting disclosure if you haven't already got it, because that's going to be the next step. If they don't give me initial disclosure, they give me a court hearing date, I'm not going to waste my time or energy going to that courthouse on a what you call preliminary hearing or first call hearing, because they just need me to enter a plea, and that can be done by appearance, because it's only a category 1 criminal offence. It's only a speeding ticket. So I hope that saves you guys some time. The only time these pricks are going to see me in court is on the defended hearing, and I hope they're all panicky. Anyway, see yous, bye.